illegal search and seizure. Now we're going to explain what that was, why it's wrong, and various court cases that have set precedents that have changed the civil liberties about illegal search and seizure.
The definition of unreasonable search and seizure is the search of an individual or his or her premises, including an automobile, and or seizure of evidence found in such a search by a law enforcement officer without a search warrant and without probable cause to believe evidence of a crime is present. Such a search and or seizure is unconstitutional under the Fourth Amendment, applied to the states by the 14th Amendment, and evidence obtained thereby may not be introduced in court. This is important because people's rights are being infringed upon.
Ohio. Dory Mapp was convicted of possessing obscene materials after an admittedly illegal police search of her home for a fugitive. She appealed her conviction on the basis of freedom of expression. The court brushed aside the First Amendment issue and declared that all evidence obtained by search and seizures in violation of the Constitution is, by the Fourth Amendment, inadmissible in a state court. Mapp had been convicted on the basis of illegally obtained evidence. In Weeks v. U.S., police entered the home of Fremont Weeks and seized papers which were used to convict him of transporting lottery tickets through the mail. This was done without a search warrant. Weeks took action against the police and petitioned for the return of his private possessions. In an unanimous decision, the court held that the seizure of items from Weeks' residence directly violated his constitutional rights.
These civil liberties have changed over time, and one example of how these rights have evolved over the period of time is the case Messerschmitt versus Millender. In this case, the ruling was that government officials have protection from civil liability, which means negative consequences pretty much, if they don't violate any laws or civil rights of people. Another example of how rights have evolved over time is the case Florida v. Harris. In this case, the Supreme Court ruled that alerts from a drug dog is not a probable cause for a search of a person or property without a warrant.